attorney Laura Anthony, founding partner of Anthony PLLC, a corporate securities and business transactions law firm. Today is the first of a Lawcast series talking about the amendments to the definitions of accelerated and large accelerated filers. In March 2020, the SEC adopted amendments to the definitions of an accelerated filer and a large accelerated filer. The amendments were adopted largely as proposed in May 2019. A company that is classified as an accelerated or large accelerated filer is subject to, among other things, the requirement that its outside auditor attest to and report on management's assessment of the effectiveness of the company's internal controls over financial reporting, called ICFR, as required by Section 404B of the Sarbanes-Oxley Act. We call that SOX. The Jobs Act exempted emerging growth companies, EGCs, from this requirement. Moreover, historically, the definition of a smaller reporting company was set such that a smaller reporting company could never be an accelerated or large accelerated filer, and as such would never be subject to Section 404B of SOX. In June 2018, the SEC amended the definition of a smaller reporting company to include companies with less than 250 million public float, increased from the previous 75 million, or if a company does not have an ascertainable public float or has a public float of less than 700 million, a smaller reporting company is one with less than 100 million in annual revenues during its most recently completed fiscal year. At that time, the SEC did not amend the definition of an accelerated filer or large accelerated filer. As a result, prior to the current amendments of large accelerated filer and accelerated filer, companies with 75 million or more of a public float that qualify as a smaller reporting company remained subject to the requirements that apply to an accelerated filer or large accelerated filer, including the accelerated timing of the filing of their periodic reports and the requirement to provide the auditor's attestation of management's assessment over internal controls as required by Section 404B of SOX. In other words, prior to the amendment of a smaller reporting company, you would never have an overlap between a smaller reporting company and an accelerated or large accelerated filer. After that amendment, you could have an overlap. Under the new rules, smaller reporting companies with less than 100 million in revenues are not required to obtain an attestation of their internal controls from an independent outside auditor under Section 404B of SOX. In particular, the amendment excludes from the accelerated and large accelerated filer definitions a company that is eligible to be a smaller reporting company and that had no revenues or annual revenues of less than 100 million in the most recent fiscal year for which audited financial statements are available. All Exchange Act reporting companies, whether a smaller reporting company, an accelerated filer, or a large accelerated filer, will continue to be required to comply with SOX Section 404A, requiring the company to establish and maintain internal controls over financial reporting and disclosure controls and procedures, and have their management assess the effectiveness of each. This management assessment is contained in the body of all quarterly and annual reports and amended reports, and in separate certifications by the company's principal executive officer and principal financial officer, which are filed as exhibits to the reports. The new rules also increase the transition thresholds for accelerated and large accelerated filers, becoming a non-accelerated filer from 50 million to 60 million, and for exiting large accelerated filer status from 500 million to 560 million, and add a revenue test to the transition thresholds for exiting both accelerated and large accelerated filer status. Like the change to the definition of a smaller reporting company, it is thought the new rules will assist with capital formation for smaller companies and reduce compliance burdens while maintaining investor protections. The SEC also hopes that the amendments will catch the attention of companies that have delayed going public in recent years, and as such may help stimulate entry into the U.S. capital markets. In the press release announcing the rule change, SEC Chair Jay Clayton stated, "The Jobs Act provided a well-reasoned exemption from the internal controls over financial reporting attestation requirement for emerging growth companies during the first 5 years after an IPO. These amendments would allow smaller reporting companies that have made it to that 5-year point but have not yet reached $100 million in revenues to continue to benefit from that exemption as they build their businesses while still subjecting those companies to important investor protection requirements." I'm securities attorney Laura Anthony, founding partner of Anthony PLLC and producer of Lawcast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.